distinguished from writ of amparo and habeas data. Q. What is the writ of amparo? How is it distinguished from the writ of habeas corpus, 2009? The petition for a writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity. The writ shall cover extralegal killings and enforce disappearances or threats thereof. The writ of amparo differs from a writ of habeas corpus in that the latter writ is availed of as a remedy against cases of unlawful confinement or detention by which any person is deprived of his liberty, or cases by which rightful custody of any person is withheld from another who is lawfully entitled thereto. Section 1, Rule 102. What is the writ of habeas data, 2009? The writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. Rules on custody of minors in writ of habeas corpus in relation to custody of minors. AM number 030404-SC. Q. While Marietta was in her place of work in Makati City, her estranged husband Carlo barged in to her house in Parañaque City, abducted their 6-year-old son, Percival, and brought the child to his hometown in Baguio City. Despite Marietta's pleas, Carlo refused to return their child. Marietta, through counsel, filed a petition for habeas corpus against Carlo in the Court of Appeals in Manila to compel him to produce their son before the court and for her to regain custody. She alleged in the petition that despite her efforts, she could not or no longer locate her son. In his comment, Carlo alleged that the petition was erroneously filed in the Court of Appeals, as the same should have been filed in the Family Court of Baguio City, which under Republic Act 8369 has exclusive jurisdiction over the petition. Marietta replied that under Rule 102 of the Rules of Court as amended, the petition may be filed in the Court of Appeals, and if granted, the writ of habeas corpus shall be enforceable anywhere in the Philippines, whose contention is correct, 2005. Marietta's contention is correct. The Court of Appeals has concurrent jurisdiction with the family courts and the Supreme Court in petitions for habeas corpus, where the custody of minors is at issue, notwithstanding the provision in the Family Courts Act RA 8369 that family courts have exclusive jurisdiction in such cases. Thornton versus Thornton. Section 20, paragraph 6 of SC AM number 030404-2003 provides the petition may likewise be filed with the Supreme Court, Court of Appeals, or with any of its members, and if so granted, the writ shall be enforceable anywhere in the Philippines. The writ may be made returnable to a family court or to any regular court within the region where the petitioner resides or where the minor may be found for hearing and decision on the merits. Writ of amparo. Q. Marinella is a junior officer of the Armed Forces of the Philippines who claims to have personally witnessed the malversation of funds given by U.S. authorities in connection with the Balikatan exercises. Marinella alleges that as a result of her expose, there are operatives within the military who are out to kill her. She files a petition for the issuance of a writ of amparo against, among others, the Chief of Staff, but without alleging that the latter ordered that she be killed. Attorney Daro, counsel for the Chief of Staff, moves for the dismissal of the petition for failure to allege that his client issued any order to kill or harm Marinella. Rule on Attorney Dario's motion, 2010. The motion to dismiss must be denied on the ground that it is prohibited pleading under Section 11, letter A of the rule on the writ of amparo. Moreover, said rule does not require the petition, therefore, to allege a complete detail of the actual or threatened violation of the victim's rights. It is sufficient that there be an allegation of real threat against petitioner's life, liberty, and/or security. General A. Razon Jr. v. Tagiris. Q. The residents of Mount Ahohoy, headed by Masigasig, formed a non-governmental organization, Alianza Laban sa Minahan, sa Ahohoy, Alma, to protest the mining operations of Oro Negro mining in the mountain. Alma members picketed daily at the entrance of the mining site, blocking the ingress and egress of trucks and equipment of Oro Negro, hampering its operations. Masigasig had an altercation with Mapusok arising from the complaint of the mining engineer of Oro Negro that one of their trucks was destroyed by Alma members. Mapusok is the leader of the Association of Peacekeepers of Ahohoy, APCA, a civilian volunteer organization serving as auxiliary force of the local police to maintain peace and order in the area. Subsequently, Masigasig disappeared. Mayumi, the wife of Masigasig, and the members of Alma searched for Masigasig, but all their efforts proved futile. Mapagmatsyag, a member of Alma, learned from Maingay, a member of APCA, during their binge drinking that Masigasig was abducted by other members of APCA. On order of Mapusok, Mayumi and Alma sought the assistance of the local police to search for Masigasig, but they refused to extend their cooperation. Immediately, Mayumi filed with the RTC a petition for the issuance of the writ of amparo against Mapusok and APCA. Alma also filed a petition for the issuance of the writ of amparo with the Court of Appeals against Mapusok and APCA. Respondents Mapusok and APCA, in their return filed with the RTC, raised, among others, their defenses that they are not agents of the state, hence cannot be impleaded as respondents in an amparo petition. Is their defense tenable? No, the defense is not tenable. The writ of amparo is a remedy available to any person whose right to life, liberty, and security has been violated or is threatened with violation by an unlawful act or omission of a public officer or employee or of a private individual or entity. The writ covers extralegal killings, enforced disappearances, or threats thereof. Section 1. The rule on the writ of amparo, AM number 07912 SC. Moreover, the rules do not require that the respondents should be agents of the state in order to be impleaded as respondents in an amparo petition. Secretary of National Defense versus Manalo. B. Respondents Mapusok and APCA, in their return, filed with the Court of Appeals, raised as their defense that the petition should be dismissed on the ground that Alma cannot file the petition because of the earlier petition filed by Mayumi with the RTC. Are the respondents correct in raising their defense? Yes, the respondents are correct in raising the defense under Section 2, letter C, of the Rules of Writ of Amparo. The filing of a petition by Mayumi, who is an immediate member of the family of the aggrieved party, already suspends the right of all other authorized parties to file similar petitions. Hence, Alma cannot file the petition because of earlier petition by Mayumi with the RTC. C. Mayumi later filed separate criminal and civil actions against Mapusok. How will the case, says, affect the amparo petition she earlier filed, 2015? When a criminal action and separate civil actions are filed subsequent to a petition for a writ of amparo, the latter shall be consolidated with the criminal action. After consolidation, the procedure under rules shall continue to apply to the disposition of the relief and the petition. Section 1. Writ of habeas data. Q. Azenith, the cashier of Temptation Investments, with principal offices in Cebu City, is equally hated and loved by her co-employees because she extends cash advances or sales to her colleagues whom she likes. One morning, Azenith discovers an anonymous letter inserted under the door of her office threatening to kill her. Azenith promptly reports the matter to her superior Joshua, who thereupon conducts an internal investigation to verify the said threat. Claiming that the threat is real, Temptation Incorporation opts to transfer Azenit to its Palawan office, a move she resists in view of the company's refusal to disclose the results of its investigation. Decrying the move as a virtual deprivation of her employment, Azenit files a petition for the issuance of a writ of habeas data before the regional trial court to enjoin Temptation Incorporation from transferring her on the ground that the company's refusal to provide her with a copy of the investigation results compromises her right to life, liberty, and privacy. Resolve the petition, 2010. Azenit petition for the issuance of a writ of habeas data must be dismissed, as there is no showing that her right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission. Neither was the company shown to be engaged in the gathering, collecting, nor storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. Section 1. Rule on the writ of habeas data. Criminal Procedure, General Matters. Q. A was charged before the Sandigan Bayan with the crime of plunder, a non-bailable offense, where the court had already issued a warrant of his arrest. Without A being arrested, his lawyer filed a motion to quash arrest, warrant, and to fix bail, arguing that the allegations in the information did not charge the crime of plunder, but a crime of malversation, a bailable offense. The court denied the motion on the ground that it had not yet acquired jurisdiction over the person of the accused and that the accused should be under the custody of the court since the crime charged was non-bailable. The accused lawyer counter-argued that the court can rule on the motion even if the accused was at large because it had jurisdiction over the subject matter of the case. According to said lawyer, there was no need for the accused to be under the custody of the court because what was filed was a motion to quash arrest and to fix bail, not a petition for bail. If you are the Sandigan Bayan, how will you rule on the motion? I will grant the motion to quash the warrant of arrest, but I will deny the motion to fix bail. A motion to fix bail is essentially an application for bail. People v. Bucalon. Relative thereto, bail is the security for the release of the person in the custody of the law. Section 1, Rule 114. The rules use the word custody to signify that bail is only available for someone who is under the custody of the law. Peter Paul Di Matula v. Honorable Cesisando Vilon, October 12, 1998. Hence, A cannot seek any judicial relief if he does not submit his person to the jurisdiction of the Sandigan Bayan. On the other hand, the Sandigan Bayan may grant the motion to quash the warrant of arrest. It is well settled that adjudication of a motion to quash a warrant of arrest requires neither jurisdiction over the person of the accused nor custody of law over the body of the accused. Otherwise stated, an accused can invoke the processes of the court, even custody of the law. Jose Miranda v. Virgilio Tuliao, March 31, 2006. Thus, Sandigan Bayan may grant the motion to quash the warrant of arrest. B. If the Sandigan Bayan denies the motion, what judicial remedy should the accused undertake? 2014. The accused may file a motion for reconsideration. If the same is denied, the accused may resort to a petition for certiorari under Rule 65 directly to the Supreme Court. Q. Governor Pedro Mario of Tarlac was charged with indirect bribery before the Sandigan Bayan for accepting a car in exchange of the award of a series of contracts for medical supplies. The Sandigan Bayan, after going over the information, found the same to be valid and ordered the suspension of Mario. The latter contested the suspension, claiming that under the law, Section 13 of RA 3019, his suspension is not automatic upon filing the information, and his suspension under Section 13 of RA 3019 is in conflict with Section 5 of the Decentralization Act of 1967, or RA 5185. The Sandigan Bayan overruled Mario's contention, stating that Mario's suspension under the circumstances is mandatory. Is the court's ruling correct? 2001. Yes, Mario's suspension is mandatory, although not automatic. Section 13, RA number 1319 in relation to Section 5 of the Decentralization Act of 1967 or RA number 5185. It is mandatory after the determination of the validity of the information in a pre-suspension hearing, Segovia v. Sandigan Bayan, March 27, 1998. The purpose of suspension is to prevent the accused public officer from frustrating or hampering his prosecution by intimidating or influencing witnesses or tampering with evidence or from committing further acts of malfeasance while in office. Jurisdiction of criminal courts. Q. Jose, Alberto, and Romeo were charged with murder. Upon filing of the information, the RTC judge issued the warrants of their arrest. Learning of the issuance of the warrants, the three accused jointly filed a motion for a reinvestigation and for the recall of the warrants of arrest. On the date set for hearing of their motion, none of the accused showed up in court for fear of being arrested. The RTC judge denied their motion because the RTC did not acquire jurisdiction over the persons of the movants. Did the RTC rule correctly? 2008. No. The court acquired jurisdiction over the person of the accused when they filed the aforesaid motion and invoked the court's authority over the case without raising the issue of jurisdiction over their person. Their filing the motion is tantamount to voluntary submission to the court's jurisdiction and contributes voluntary appearance. Miranda v. Tuliao. Q. In complex crimes, how is the jurisdiction of a court determined? 2003. In a complex crime, jurisdiction over the whole complex crime must be lodged with the trial court having jurisdiction to impose the maximum and most serious penalty imposable on an offense forming part of the complex crime. Cuyas v. Garcia, April 15, 1988. Q. Mariano was convicted by the RTC for raping Victoria and meted the penalty of reclusion perpetua. While serving sentence at the National Penitentiary, Mariano and Victoria were married. Mariano filed a motion in said court for his release from the penitentiary on his claim that under Republic Act No. 8353, his marriage to Victoria extinguished the criminal action against him for rape as well as the penalty imposed on him. However, the court denied the motion on the ground that it had lost jurisdiction over the case after its decision had become final and executory. Is the filing of the court correct? Explain. No, the court can never lose jurisdiction so long as its decision has not yet been fully implemented and satisfied. Finality of a judgment cannot operate to divest a court of its jurisdiction. The court retains an interest in seeing the proper execution and implementation of its judgments, and to that extent may issue such orders necessary and appropriate for these purposes. Echegaray v. Secretary of Justice. B. What remedy or remedies should the counsel of Mariano take to secure his proper and most expeditious release from the National Penitentiary? 2005. To secure the proper and most expeditious release of Mariano from the National Penitentiary, his counsel should file a petition for habeas corpus for the illegal confinement of Mariano, Rule 102, or b. a motion in court which convicted him to nullify the execution of his sentence or the order of his commitment on the ground that a supervening development had occurred. Melo v. People. Despite the finality of the judgment, when injunction may be issued to restrain criminal prosecution. Will the injunction lie to restrain the commencement of a criminal action? 1999. Answer. As a general rule, injunction will not lie to restrain a criminal prosecution except 1. To afford adequate protection to the constitutional rights of the accused. 2. When necessary for the orderly administration of justice or to avoid the oppression of multiplicity of actions. 3. When double jeopardy is clearly apparent. 4. Where the charges are manifestly false and motivated by the lust for vengeance. And 5. Where there is clearly no prima facie case against the accused and a motion to quash on that ground has been denied. See cases cited in Roberts Jr. v. Court of Appeals, TR 113930, March 5, 1996, and Broca v. Ponce and Rile, December 10, 1990. Prosecution of offenses. Distinguish a complaint from information, 1999. In criminal procedure, a complaint is a sworn written statement charging a person with an offense, subscribed by the offended party. Any peace officer or other peace officer charged with the enforcement of the law violated. Section 3, Rule 110, 1985 Rules of Criminal Procedure. While an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Section 4. Q. While in his Nissan patrol and hurrying home to Quezon City from his work in Makati, Gary figured in a vehicular mishap along that portion of EDSA within the city of Mandaluyong. He was bumped from behind by a Ford Expedition SUV driven by Horace, who was observed using his cellular phone at the time of the collision. Both vehicles, more than 5 years old, no longer carried insurance other than the compulsory third-party liability insurance. Gary suffered physical injuries while his Nissan Patrol sustained damage in excess of 500,000 pesos. As counsel for Gary described the process you need to undertake starting from the point of the incident, if Gary would proceed criminally against Horace, and identify the court with jurisdiction over the case. As counsel for Gary, I will first make him medically examined in order to ascertain the gravity and extent of the injuries he sustained from the accident. Second, I will secure a police report relative to the mishap. Third, I will ask him to execute his sinumpang salaysay. Thereafter, I will use his sinumpang salaysay or prepare a complaint affidavit and file the same in the office of the city prosecutor and later on to the appropriate MTC of Mandaluyong City for the crime of reckless imprudence resulting to physical injuries and damage to property. Section 1 and 15 Rule 110. B. If Gary chooses to file an independent civil action for damages, explain briefly this type of action, its legal basis, the different approaches in pursuing this type of action, the evidence you would need, and types of defenses you could expect. 2013. A. An independent civil action is an action which is entirely distinct and separate from the criminal action. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Section 3 of Rule 111 allows the filing of an independent civil action by the offended party based on Article 33 and 2176 of the new Civil Code. The different approaches that the plaintiff can pursue in this type of action are as follows. 1. File the independent criminal action and prosecute the criminal case separately. 2. File the independent criminal action without filing the criminal case. 3. File the criminal case without need of reserving the independent civil action. Aside from the testimony of Gary, the pieces of evidence that would be required in an independent civil action are the medical report and certificate regarding the injuries sustained by Gary, hospital and medical bills including receipt of payments made, police report and proof of the extent of damage sustained by his car, and the affidavit of witnesses who saw Horace using his cellular phone at the time the incident happened. I will also present proof of employment of Gary, such as his payslip, in order to prove that he was gainfully employed at the time of the mishap, and as a result of the injuries he suffered, he was not able to earn his usual income thereof. I will also present the attending doctor of Gary to corroborate and authenticate the contents of the medical report and abstract thereof. The evidence required to hold defendant Horace liable is only preponderance of evidence. The types of defendants that may be raised against this action are fortuitous event, force majeure, or acts of God. The defendant can also invoke contributory negligence as partial defense. Moreover, the defendant can raise the usual defenses that the 1. Plaintiff will be entitled to double compensation or recovery, and B. Defendant will be constrained to litigate twice and therefore suffer the cost of litigation twice. Q. On its way to the PNP Academy in Silang, Cavite, on board a public transport bus as a passenger, Police Inspector Masigasi of the Valenzuela Police witnessed an ongoing armed robbery while the bus was traversing Makati. His alertness and training enabled him to foil the robbery and to subdue the malefactor. He disarmed the felon, and while frisking him, discovered another handgun tucked in his waist. He seized both handguns, and the malefactor was later charged with the separate crimes of robbery and illegal possession of firearm. Where should Police Inspector Masigasid bring the felon for criminal processing? To Silang Cavite, where he is bound, or to Makati, where the bus actually was when the felonies took place, or back to Valenzuela, where he is stationed? Which court has jurisdiction over the criminal cases? 2013. Police Inspector Masigasig should bring the felon to the nearest police station or jail in Makati City, where the bus actually was when the felonies took place. Moreover, where an offense is committed in a public vehicle while in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such vehicle passed during its trip, including the place of its departure and arrival. Section 15, letter B, Rule 110. Consequently, the criminal case for robbery and illegal possession of firearms can be filed in Regional Trial Court of Makati City or on any of the places of departure or arrival of the bus. Q. Yvonne, a young and lonely OFW, had an intimate relationship abroad with a friend, Percy. Although Yvonne comes home to Manila every 6 months, her foreign posting still left her husband Dario lonely, so that he also engaged in his own extramarital activities. In one particular exhilarating session with his girlfriend, Dario died. Within 180 days from Dario's death, Yvonne gives birth in Manila to a baby boy. Irate relatives of Dario contemplate criminally charging Yvonne for adultery, and they hire a law firm to handle the case. Is the contemplated criminal action a viable option to bring? No. Section 5 of Rule 110 provides that the crimes of adultery and concubinage shall not be prosecuted except upon complaint by the offended spouse. Since the offended party is already dead, then the criminal action for adultery, as contemplated by offended party's relatives, is no longer viable. Is a civil action to impugn the paternity of the baby boy feasible? And if so, in what proceeding may such issue be determined? 2013. Yes. Under Article 171 of the Family Code, the heirs of the husband may impugn the filiation of the child in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint without having desisted therefrom. Or 3. If the child was born after the death of the husband. Since Dario is already dead when the baby boy was born, his heirs have the right to impugn the filiation of the child. Consequently, the heirs may impugn the filiation either by a direct action to impugn such filiation, or raise the same and a special proceeding for settlement of the state of the decedent. In the said proceeding, the probate court has the power to determine questions as to who are the heirs of the decedent. Reyes v. Isip et al. Jimenez v. Intermediate Appellate Court. Incidentally, the heirs can also submit the baby boy for DNA testing. Rule on DNA Evidence, AM number 6115 SC, or even blood tests in order to determine paternity and filiation. In Zhao v. Court of Appeals, the Supreme Court held that blood grouping tests are conclusive as to non-paternity, although inconclusive as to paternity. The fact that the blood type of the child is a possible product of the mother and alleged father does not conclusively prove that the child is born by such parents. But if the blood type of the child is not the possible blood type, when the blood type of the mother and that of the alleged father are cross-matched, then the child cannot possibly be that of the alleged father. Q. Your friend YY, an orphan, 16 years old, seeks your legal advice. She tells you that ZZ, her uncle, subjected her to acts of lasciviousness, that when she told her grandparents, they told her to just keep quiet and not to file charges against CC, their son. Feeling very much aggrieved, she asked you how her uncle CC can be made to answer for his crime. What would your advice be? Explain. I would advise the minor an orphan of 16 years of age, to file the complaint herself, independently of her grandparents, because she is not incompetent or incapable of doing so upon grounds other than her minority. Section 5, Rule 110. B. Suppose the crime committed against YY by her uncle ZC is rape, witnessed by your mutual friend XX, but this time YY was prevailed upon by her grandparents not to file charges. XX asks you if she can initiate the complaint against ZC. Would your answer be the same? 2000. Since rape is now classified as a crime against persons under the anti-rape law of the 1997 RA 8353, I would advise XX to initiate the complaint against ZZ. Q. X was arrested in flagrante for robbing a bank. After the investigation, he was brought before the office of the prosecutor for inquest. But unfortunately, no inquest prosecutor was available. May the bank directly file the complaint with the proper court? If in the affirmative, what document should be filed? 2012. Yes, the bank may directly file the complaint with the proper court. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Section 6, Rule 12. Designation of offense. Q. The prosecution filed an information against Jose for slight physical injuries, alleging the acts constituting the offense, but without any more alleging that it was committed after Jose's unlawful entry in the complainant's abode. Was the information correctly prepared by the prosecution? Y. 2001. No. The aggravating circumstance of unlawful entry in the complainant's abode has to be specified in the information, otherwise it cannot be considered as aggravating. Section 8, Rule 110. Amendment or substitution of complaint or information. Q. D and E were charged with homicide in one information. Before they could be arraigned, the prosecution moved to amend the information to exclude E therefrom. Can the court grant the motion to amend? Y. 2001 and 2002. Yes, provided notice is given to the offended party and the court states its reasons for granting the same. Section 14, Rule 110. B. On the facts above stated, suppose the prosecution, instead of filing a motion to amend, moved to withdraw the information altogether, and its motion was granted. Can the prosecution refile the information, although this time for murder? Explain. Yes, the prosecution can refile the information for murder in substitution of the information for homicide, because no double jeopardy has yet attached. Galvez v. Court of Appeals. Q. A was accused of homicide for the killing of B. During the trial, the public prosecutor received a copy of the marriage certificate of A and B. Can the public prosecutor move for the amendment of the information to charge A with the crime of parricide? No. The information cannot be amended to change the offense charge from homicide to parricide. Firstly, the marriage is not a supervening fact arising from the act constituting the charge of homicide. Section 8, Rule 110. Suppose instead of moving for the amendment of the information, the public prosecutor presented in evidence the marriage certificate without objection on the part of the defense. Could A be convicted of parricide? 1997. No. A can be convicted only of homicide, not of parricide, which is a graver offense. The accused has the constitutional rights of due process and to be informed of the nature and the cause of the accusation against him. Section 1, 14, 1, and 2, Article 3, 1987 Constitution. Prosecution of civil action. Q. While cruising on a highway, a taxicab driven by Mans hit an electric post. As a result thereof, its passenger Jovi suffered serious injuries. Mans was subsequently charged before the municipal trial court with reckless imprudence resulting in serious physical injuries. Thereafter, Jovi filed a civil action against Lourdes, the owner of the taxicab, for breach of contract, and Mans for quasi-delict. Lourdes and Mans filed a motion to dismiss the civil action on the ground of litis pendentia, that is, the pendency of the civil action impliedly instituted in the criminal action for reckless imprudence resulting in serious physical injuries. Resolve the motion with reason. 2005. The motion to dismiss should be denied. The action for breach of contract against the taxi cab owner cannot be barred by the criminal action against the taxi cab driver, although the taxi cab owner can be held subsidiarily liable in the criminal case if the driver is insolvent. On the other hand, the civil action for quasi-delict against the driver is an independent civil action under Article 33 of the Civil Code and Section 3, Rule 111 of the Rules of Court, which can be filed separately and can proceed independently of the criminal action and regardless of the result of the latter. Sampson versus Dawai, July 21, 2004. Q. Name two instances where the trial court can hold the accused civilly liable even if he is acquitted. 2002-2010 bar. The instances where the civil liability is not extinguished despite acquittal of the accused are: 1. Where the acquittal is based on reasonable doubt. B. Where the court expressly declares that the liability of the accused is not criminal, but only civil in nature. And 3. Where the civil liability is not deprived from or based on the criminal act of which the accused is acquitted. Remedios Nota Sapiera v. Court of Appeals. Q. In an action for violation of Batas Pambansa, Bilang 22, the court granted accused demurrer to evidence, which he filed without leave of court. Although he was acquitted of the crime charged, he, however, was required by the court to pay the private complainant the face value of the check. The accused filed a motion of reconsideration regarding the order to pay the face value of the check on the following grounds. A. The demurrer to evidence applied only to the criminal aspect of the case, 2001. The motion for reconsideration should be denied. The ground that the demurrer to evidence applied only to the criminal aspect of the case was not correct because the criminal action for violation of Batas Pambansa 22 included the corresponding civil action. B. At the very least, he was entitled to adduce controverting evidence on the civil liability. Resolve the motion for reconsideration 2003. The accused was not entitled to adduce controverting evidence on the civil liability because he filed his demurrer to evidence without leave of court. Section 23, Rule 119. Prejudicial question. Q. A allegedly sold to B a parcel of land, which A later also sold to X. B brought a civil action for nullification of the second sale and asked that the sale made by A in his favor be declared valid. A theorized that he never sold the property to B, and his purported signatures appearing in the first deed of sale were forgeries. Thereafter, an information for estafa was filed against A based on the same double sale that was the subject of the civil action. A filed a motion for suspension of action in the criminal case, contending that the resolution of the issue in civil case would necessarily be determinative of his guilt or innocence. Is the suspension of the criminal action in order? Explain 1999-2000. Yes. The suspension of the criminal action is in order because the defense of A in civil action that he never sold the property to B and that his purported signatures in the first deed of sale were forgeries is a prejudicial question, that resolution of which is determinative of his guilt or innocence. If the first sale is null and void, there would be no double sale, and A would be innocent of the offense of estafa. Russ versus Razul. Q. Solomon and Faye got married in 2005. In 2010, Solomon contracted a second marriage with Hope. When Faye found out about the second marriage of Solomon and Hope, she filed a criminal case for bigamy before the Regional Trial Court of Manila sometime in 2011. Meanwhile, Solomon filed a petition for declaration of nullity of his first marriage with Faith in 2012, while the case for bigamy before the RTC of Manila is ongoing. Subsequently, Solomon filed a motion to suspend the proceedings in the bigamy case on the ground of prejudicial question. He asserts that the proceedings in the criminal case should be suspended because of his first marriage with Faith will be declared null and void. It will have the effect of exculpating him from the crime of bigamy. Decide 2014. The motion filed by Solomon should be denied. The elements of prejudicial question are: 1. The previous instituted civil action involves an issue similar or intimately related to the issue determines in the subsequent criminal action, and 2. The resolution of such issue determines whether or not the criminal action may proceed. In order for a prejudicial question to exist, the civil action must precede the filing of the criminal action. Dreamwork Construction versus Janyola. Since the criminal case for bigamy was filed ahead of the civil action for declaration of nullity of marriage, there is no prejudicial question. At any rate, the outcome of the civil case for annulment has no bearing upon the determination of the guilt or innocence of the accused in the criminal case for bigamy, because the accused has already committed the crime of bigamy when he contracted the second marriage without the first marriage having been declared null and void. Otherwise stated, he who contracts marriage during the subsistence of a previously contracted marriage runs the risk of being prosecuted for bigamy. Preliminary investigation. Q. Regional Director AG of the Department of Public Works and Highways was charged with violation of Section 3, letter E of Republic Act No. 3019 in the Office of the Ombudsman. An administrative charge for gross misconduct arising from the transaction, subject matter of said criminal case, was filed against him in the same office. The Ombudsman assigned a team composed of investigators from the Office of the Special Prosecutor and from the Office of the Deputy Ombudsman for the military to conduct a joint investigation of the criminal case and the administrative case. The team of investigators recommended to the Ombudsman that AG be preventively suspended for a period not exceeding 6 months on its finding that the evidence of guilt is strong. The Ombudsman issued the said order as recommended by the investigators. AG moved to reconsider the order on the following grounds. A. The Office of the Special Prosecutor had exclusive authority to conduct a preliminary investigation of the criminal case. B. The order for his preventive suspension was premature because he has yet to file his answer to the administrative complaint and submit countervailing evidence. And C. He was Career Executive Service Officer and under Presidential Decree No. 807, Civil Service Law. His preventive suspension shall be for a maximum period of 3 months. Resolved with reasons, the motion of Respondent AG, 2005. The motion should be denied for the following reasons. 1. The Office of the Special Prosecutor does not have exclusive authority to conduct a preliminary investigation of the criminal case, but it participated in the investigation together with the Deputy Ombudsman for the military who can handle cases for civilians and is not limited to the military. Number 2. The order of preventive suspension need not wait for the answer to the administrative complaint and the submission of countervailing evidence. Garcia versus Mojica. Q. X, an Undersecretary of DNR, was charged before the Sandigan Bayan for malversation of public funds, allegedly committed when he was still the mayor of a town in Rizal. After arraignment, the prosecution moved that X be preventively suspended. X opposed the motion, arguing that he was now occupying a position different from that which the information charged him, and therefore there is no more possibility that he can intimidate witnesses and hamper the prosecution. Decide. Suppose X files a motion to quash challenging the validity of the information and the Sandigan Bayan denies the same. Will there still be a need to conduct a pre-suspension hearing? 2012. There is no necessity for the court to conduct pre-suspension hearing. Under Section 13 of RA number 3019, an incumbent public officer against whom any criminal prosecution under a valid information for graft-related crime such as malversation is pending in court shall be suspended from office. The word office from which the public officer charged shall be preventively suspended could apply to any office which he might currently be holding, and not necessarily the particular office under which he was charged. Thus, the DNR Undersecretary can be preventively suspended even though he was a mayor when he allegedly committed malversation. Settled is the rule that where the accused files a motion to quash the information or challenges the validity thereof, a show cause order of the trial court would no longer be necessary. What is indispensable is that the trial court duly hear the parties at a hearing held for determining the validity of the information, and thereafter hand down its ruling, issuing the corresponding order of suspension, should it uphold the validity of the information. Luciano versus Mariano. Since a pre-suspension hearing is basically a due process requirement, when an accused public official is given an adequate opportunity to be heard on his possible defenses against the mandatory suspension under RA number 319, then an accused would have no reason to complain that no actual hearing was conducted. Miguel v. versus the Honorable Sandigan Bayan. In the facts given, the DENR Undersecretary was already given opportunity to question the validity of the information for malversation by filing a motion to quash, and yet the Sandigan Bayan sustained its validity. There is no necessity for the court to conduct pre-suspension hearing to determine for the second time the validity of the information for purposes of preventively suspending the accused. Q. You are the defense counsel of Angela Between, who has been charged under RA 3019, Anti-Graft and Corrupt Practices Act, before the Sandigan Bayan. While Angela has posted bail, she has yet to be arraigned. Angela revealed to you that she has not been investigated for any offense, and that it was only when police officers showed up at her residence with a warrant of arrest that she learned of the pending case against her. She wonders why she has been charged before the Sandigan Bayan when she is not a government service. What before trial remedy would you invoke in Angela's behalf to address the fact that she had not been investigated at all, and how would you avail of this remedy? I will file a motion for the conduct of preliminary investigation or reinvestigation and the quashal or recall of the warrant of arrest in the court where the case is pending, with an additional prayer to suspend the arraignment. Under Section 6, Rule 112 of the Rules of Court, after filing of the complaint or information in court without the preliminary investigation, the accused may within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense. Moreover, Section 26, Rule 114 of the Rules of Criminal Procedure provides that an application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefor, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable, but not later than the start of the trial of the case. B. What during trial remedy can you use to allow an early evaluation of the prosecution evidence without the need of presenting defense evidence? When and how can you avail of this remedy? 2013. I will file first a motion for leave to file a demurrer within 5 days from the time the prosecution rested its case. If the same is granted, then I will now file a demurrer to evidence within 10 days. Section 23, Rule 119. This remedy would allow the evaluation of the sufficiency of prosecution's evidence without the need of presenting defense evidence. It may be done through the court's initiative or upon motion of the accused and after the prosecution rested its case. Section 23, Rule 119. Q. On his way to the PNP Academy in Silang, Cavite, on board a public transport bus as a passenger, Police Inspector Masigasig of the Valenzuela Police witnessed an ongoing armed robbery while the bus was traversing Makati. His alertness and training enabled him to foil the robbery and to subdue the malefactor. He disarmed the felon and while frisking him, discovered another handgun tucked in his waist. He seized both handguns, and the malefactor was later charged with the separate crimes of robbery and illegal possession of firearm. May the charges of robbery and illegal prosecution of firearm be filed directly by the investigating prosecutor with the appropriate court without a preliminary investigation. 2013. Yes, since the offender was arrested in flagrante delicto without a warrant of arrest, an inquest proceeding should be conducted and thereafter a case may be filed in court even without the requisite preliminary investigation. Under Section 7, Rule 112, when a person is lawfully arrested without a warrant involving an offense which requires preliminary investigation, the complaint or information may be filed by a prosecutor without the need of such investigation provided an inquest has been conducted in accordance with existing rules. In the absence of an availability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Arrest. Q. As Cicero was walking down a dark alley one midnight, he saw an owner-type jeepney approaching him. Sensing that the occupants of the vehicle were up to no good, he darted into a corner and ran. The occupants of the vehicle, elements from the Western Police District, gave chase and apprehended him. The police apprehended Cicero, frisked him, and found a sachet of 0.09 gram of shabu tucked in his waist and a Swiss knife in his secret pocket, and detained him thereafter. Is the arrest and body search legal? 2010. No. The arrest and the body search were not legal. Cicero's act of running does not show any reasonable ground to believe that a crime has been committed or is about to be committed for the police officers to apprehend him and conduct body search. Hence, the arrest was illegal as it does not fall under any of the circumstances for a valid warrantless arrest provided in Section 5, Rule 113 of the Rules of Criminal Procedure. Q. AEX swindled RY in the amount of 10,000 pesos sometime in mid-2003 on the strength of the sworn statement given by RY personally to SPO1 Juan Ramos sometime in mid-2004, and without securing a warrant, the police officer arrested AX. Forthwith, the police officer filed with the city prosecutor of Manila a complaint for estafa supported by RY's sworn statement and other documentary evidence. After due inquest, the prosecutor filed the requisite information with the MMRTC. No preliminary investigation was conducted either before or after the filing of the information, and the accused at no time asked for such an investigation. However, before arraignment, the accused moved to quash the information on the ground that the prosecutor suffered from a want of authority to file the information because of his failure to conduct a preliminary investigation before filing the information as required by the rules of court. Is the warrantless arrest of AX valid? No, the warrantless arrest is not valid because the alleged offense has not just been committed. The crime was allegedly committed 1 year before the arrest. Section 5, letter B, Rule 113. B. Is he entitled to a preliminary investigation before the filing of the information? Explain. 2004. Yes, he is entitled to a preliminary investigation because he was not lawfully arrested without a warrant. Section 7, Rule 112. He can move for a re-investigation. Q. A was killed by B during a quarrel over a hostess in a nightclub. 2 days after the incident, and upon complaint of the widow of A, the police arrested B without a warrant of arrest and searched his house without a search warrant. Can the gun used by B in shooting A, which was seized during the search of the house of B, be admitted in evidence? No. The gun seized during the search of the house of B without a search warrant is not admissible in evidence. Section 2 and 3, Number 2, Article 3, 1987 Constitution. Moreover, the search was not an incident to a lawful arrest of a person under Section 13, Rule 126. Is the arrest of B legal? No. A warrantless arrest requires that the crime has in fact just been committed, and the police arresting has personal knowledge of facts that the person to be arrested has committed it. Section 5, Rule 113. Here, the crime has not just been committed since a period of 2 days had already elapsed, and the police arresting has no such personal knowledge because he was not present when the incident happened. Go versus Court of Appeals, February 11, 1992. C. Under the circumstances, can B be convicted of homicide? 1997. Yes. The gun is not indispensable in the conviction of A because the court may rely on testimonial or other evidence. Q. In a buy-bust operation, the police operatives arrested the accused and seized from him a sachet of shabu and an unlicensed firearm. The accused was charged in two informations, one for a violation of the Dangerous Drug Act, as amended, and another for illegal possession of firearms. The accused filed an action for recovery of the firearm in another court against the police officer with an application for the issuance of a writ of replevin. He alleged in his complaint that he was a military informer who had been issued a written authority to carry said firearm. The police officers moved to dismiss the complaint on the ground that the subject firearm was in custodia legis. The court denied the motion and instead issued the writ of replevin. Was the seizure of the firearm valid? Yes, the seizure of the firearm was valid because it was seized in the course of a valid arrest in a buy-bust operation, Sections 12 and 13, Rule 126. A search warrant was not necessary, People v. Salazar. Was the denial of the motion to dismiss proper? 2003. No. The denial of the motion to dismiss was not proper. The court had no authority to issue the writ of replevin whether the firearm was in custodia legis or not. The motion to recover the firearm should be filed in the court where the criminal action is pending. Q. F.G. was arrested without a warrant by policemen while he was walking in a busy street. After the preliminary investigation, he was charged with rape and the corresponding information was filed in the RTC. On arraignment, he pleaded not guilty. Trial on the merits ensued. The court rendered judgment convicting him. On appeal, F.G. claims that the judgment is void because he was illegally arrested. If you were the Solicitor General, Counsel for the People of the Philippines, how would you refute said claim? 2000. Any objection to the illegality of the arrest of the accused without a warrant is deemed waived when he pleaded not guilty at the arraignment without raising the question. It is too late to complain about a warrantless arrest after trial is commenced and completed and a judgment of conviction rendered against the accused. People v. Cabiles. Q. Under Section 5, Rule 113, a warrantless arrest is allowed when an offense has just been committed and the peace officer has probable cause to believe, based on his personal knowledge of facts and circumstances, that the person to be arrested has committed it. A policeman approaches you for advice and asks you how he will execute a warrantless arrest against a murderer who escaped after killing a person. The policeman arrived 2 hours after the killing, and a certain Max was allegedly the killer, per information given by a witness. He asks you to clarify the following. A. How long after the commission of the crime can he still execute the warrantless arrest? B. What does personal knowledge of the facts and circumstances that the person to be arrested committed it mean? 2016 bar. Letter A. In executing a warrantless arrest under Section 5, Rule 113, the Supreme Court held that the requirement that an offense has just been committed means that there must be a large measure of immediacy between the time the offense was committed and the time of the arrest. Joey M. Pestillos v. Moreno Generoso, November 10, 2014. If there was an appreciable lapse of time between the arrest and the commission of the crime, a warrant of arrest must be secured. In any case, personal knowledge by the arresting officer is an indispensable requirement to the validity of a valid warrantless arrest. The exact period varies on a case-to-case basis. In People v. Gerente, March 10, 1993, the Supreme Court ruled that a warrantless arrest was validly executed upon the accused 3 hours after the commission of the crime. In People v. Tonog Jr., the Supreme Court likewise upheld the valid warrantless arrest, which was executed on the same day as the commission of the crime. However, in People v. Del Rosario, the Supreme Court held that the warrantless arrest effected a day after the commission of the crime is invalid. In Go v. Court of Appeals, the Supreme Court also declared invalid a warrantless arrest effected 6 days after the commission of the crime. Answer to letter B. The phrase personal knowledge of the facts and circumstances that the person to be arrested committed it means that matters in relation to the supposed commission of the crime were within the actual perception, personal evaluation, or observation of the police officer at the scene of the crime. Thus, even though the police officer has not seen someone actually fleeing, he could still make a warrantless arrest if, based on his personal evaluation of the circumstances at the scene of the crime, he could determine the existence of probable cause that the person sought to be arrested has committed the crime. However, the determination of probable cause and the gathering of facts or circumstances should be made immediately after the commission of the crime in order to comply with the element of immediacy. The arresting officer's determination of probable cause under Section 5, letter B, Rule 113 of the Revised Rules of Criminal Procedure is based on his personal knowledge of the facts or circumstances that the person sought to be arrested has committed a crime. These facts or circumstances pertain to actual facts or raw evidence, like supported by circumstances sufficiently strong in themselves to create the probable cause of guilt on the person to be arrested. A reasonable suspicion, therefore, must be founded on probable cause, coupled with good faith on the part of the peace officers making the arrest. The probable cause to justify warrantless arrest ordinarily signifies a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious man to believe that the person accused is guilty of the offense with which he is charged, or an actual belief or reasonable ground of suspicion based on actual facts. Joey M. Pestillas v. Moreno Generoso, November 10, 2014.